Well, good morning, everybody, and welcome to today's webinar on UK sales channels and contracts made simple. My name's Richard Howard, and I'm a market advisor based in Enterprise Island, London office within the new exporters team, and I'll be your moderator today. Thanks very much for joining us. And really the goal today is to help you navigate a couple of critical aspects around entering and growing into the UK market. So the first thing we're looking to cover is to understand the legal considerations around different types of sales contracts. And the second aspect of today is to learn from real world experiences of companies who've successfully managed different sales channels. So we're going to start with a short presentation from Lucy Pringle, a partner at Keystone Law, who's going to share those key legal insights. And then for the second half of the presentation, we'll move into a panel discussion with three brilliant companies, Micron, Agritech, Tynes, and Rathbornes 1488, who are going to share some of their practical experiences when it comes to navigating different sales channels within the UK. So the chat function is open during today's webinar. So any questions that you have, please post them within the chat on Teams at any time during the session, and we'll get to them as we go. And as a reminder, the session today is being recorded, and the recording as well as the slides will be made available to you following the webinar. So without further delay, and to kick things off, Lucy, delighted to introduce you to guide us through the first part of the presentation. So over to you.
Thanks, Richard. As Richard said, I am a partner at Keystone Law. I specialise in commercial contracts. So if we could just have a look at the next slide, please. I'll give you a bit of a flair for the kind of thing that I do. So I help businesses who want to trade internationally with their contracts. That's the essence of what I do. So I help them with their routes to market. So that might be direct sales or agency, distribution, franchising, influencers. And we'll be touching on a lot of those things today. And everything to do with global supply chain, basically warehousing, logistics, how you get your goods around the world using contracts. Okay. Next slide, please. So it's very exciting when you are looking at a big map of the world and thinking, oh, I've done well, I've established myself in my local market, but where else could I sell? So expanding internationally can open up potentially exponential growth, new customers, new revenue streams, but obviously it's not without its challenges. Particularly because wherever you're selling into, you're going to have to get to grips with the local laws in that place. The logistics of getting your goods into overseas markets can be quite complicated, particularly when you're shipping outside the EU. And obviously today's focus is selling from the UK, from Ireland into the UK. And if you're going to work with overseas partners, you need to be able to trust them. So contracts are really the bedrock of success for international trading because they protect your interests, they set out the expectations, and they help you avoid potentially costly disputes. So a really crucial tool in your international trading armory. So today's focus is on selling goods from Ireland into the UK, but the same principles apply on a very similar basis no matter where you are selling your goods to. So if you were selling your goods into France, Germany, the US, a lot of the stuff we're going to talk about today will apply equally. So hopefully it should stand you in good stead in terms of broader expansion plans as well. Now, obviously, if you were selling selling further afield, you would have additional considerations to take into account, things like language differences, culture, etc., where obviously the UK and Ireland don't differ very much, not too much in comparison to kind of selling into Asia, South America, etc. So you would have some additional considerations, but the routes to market are very similar. So let's talk about those routes to market. The principal ones that we're going to be talking about today are making direct sales into the local market, using agents, using distributors, and using digital marketing. So contracts, we've said, are very, very important, but there are other things you need to consider, things like the regulations, the local laws, cultural issues, logistics, and also tax. Okay, so let's move to the next slide and start to look at some of these points in detail. So the first thing we're going to look at is direct sales. Okay, now there are lots of ways, lots of different methods for making direct sales into an overseas market. It might be that you have your own website and people find your website on the internet and they place an order from your website and you then ship the goods overseas directly to that customer. It could be that you don't even have a website. People just contact you by email and you make a distance selling contract. Okay. So that's kind of the lightest touch in terms of the investment that you would have to make in securing those sales. Starting to get into sort of more involved methods, you might sign up to an online marketplace. So you might say, the best way for me to get my goods into the UK market is via Amazon. So you enter into a contract to sell your goods via Amazon. Going a step further, it might be that you decide to physically land in the UK, you want to open a store, you want to incorporate a local entity and start to trade directly in the UK. Okay, so there are lots of different ways that you can sell directly. With all of those methods, bar perhaps Amazon, you can control your pricing and your sales terms. You are responsible for what terms you sell your goods or your services on, and you've got nobody taking a cut. The challenges are obviously you've got to go out and find those customers. So this is the massive stumbling block that makes most people consider other options like agency and distribution. So you don't necessarily know people in the local market. It might be that you want to sell to wholesalers or directly to retail stores or directly to end consumers. But how do you find those customers? So that can involve a lot of marketing. You also then need to make sure you're complying with local laws. So in the UK, you'd need to be complying with things like e-commerce regulations if you're doing marketing. And then you also need to think about whether you're actually going to need to incorporate a local entity to make those sales from that local entity within the UK. Okay. So the first thing that you need is a form of contract that governs your obligations in respect of the sale of your goods or the provision of your services or the license of your software to your customer in the UK. Okay, so this one is kind of the most straightforward in terms of the contract. It's just a contract between you and the overseas customer, but it's got the biggest hurdles in terms of finding those customers and the obligation to build up the requirement to build up your own market. Okay, next slide, please. So when you are thinking, right, I just need one contract, I just need this sales contract, and whether it's for goods, services, or software, a lot of the principles are going to be the same. You're going to need warranties. And so warranties are really important because they set out your specific obligations in respect of what you have got to do, and then they limit them. We don't want open-ended quality obligations, for example. And you might think, oh, I'd be better off just not putting any warranties in my contract. Well, in the UK, that would mean that the Sale of Goods Act would apply by default as a contract term. And that contains very woolly warranties that are not limited in duration and are quite ambiguous in terms of how they can be interpreted. And often that's interpreted in favour of the customer. So suppliers nearly always say the Sale of Goods Act does not apply to this contract, and instead we're going to put our own warranties in and exclude those implied terms under the Sale of Goods Act. Now that is absolutely fine if you are working on a business-to-business basis. If you are selling to consumers, the position is obviously very different because consumers are afforded a much higher level of protection, so you can't avoid the statutory terms with consumers. But if you're working on a business-to-business basis, we're going to say this is our quality obligation, these are the warranties you get, this is how long they last, and then after that, we have discharged our obligations, we have no further liability. So that's really important. The next thing we're going to think about, particularly if you're selling goods, is what are the delivery terms? So if you need to transfer the goods from one country to another, obviously there's going to be some sort of shipment involved. Now, Incoterms are the sort of international shortcut for what delivery terms to use, and we're going to talk about those a little bit more in detail later on in the presentation. But they cover things like the cost, responsibility, and risk in the goods during that transit process. Next thing you need to think about in terms of delivery lead times. How long do you need between the customer placing an order and you getting the goods out to them? Or are you committing to firm delivery dates? So that's we want to use our contract to define our responsibility with respect to delivery. And if it's services, then it would be with respect to performance times. Then remedies. What if things go wrong? So what about if the goods you deliver are defective or the services that you perform are not good enough? What about if there are delays? Or what about if you fail to perform? And that could be for a reason outside your control or a reason within your control. In those circumstances, what remedies are you prepared to offer the customer? Now, normally you would say, a bit like the warranties, isn't it better just not to offer any remedies? Well, actually, it can be much more beneficial to specify specific remedies you are willing to offer and then say, and that's your lot. Once we've discharged those remedies, you don't get to sue us for breach of contract on top. So that's why we like to specify some limited remedies in contracts. And then we also like to put a big wrapper around your obligations in the form of a liability cap. So we say this is the maximum amount of liability I will have in pound, shilling and pence or euros, whatever it might be. And then there are certain liabilities such as indirect loss, loss of profit, loss of revenue, etc., that I just don't take any responsibility for. So your contract is an incredibly important tool for capping and managing your liability. Other important things we would obviously be thinking about are the price and how you get paid. And you might also want to think about payment security. And this payment security becomes more of an issue in international trade than domestic trade, because there can be a greater lag time between you dispatching your goods and you receiving payment for them. Okay, so payment security is something you do want to give some thought to. You might also want to think about what currency you're being paid in and whether you need any foreign exchange mechanism in your contract. So, for example, if your customer is paying for the goods in pound sterling, but you are incurring all of your costs in euros, and you have a long-term contract in place, then you might think, well, over time, there could be some fairly substantial fluctuations between those two currencies, and therefore I need some sort of mechanism to protect me against those as well. So if you have a long-term arrangement, you might also be thinking about a Forex mechanism in your contract. And then the final big point that we want to cover and is very important in international trade is which governing law applies to the contract. And if there is a dispute, what is the forum for those disputes being resolved? So are you going to be contracting under Irish law or English law? And if there is a dispute, is it going to the English courts to be determined, or maybe arbitration in the UK, or do you want to use the Irish courts? If you are contracting with customers, you will definitely need to go for the English courts because consumers are entitled to bring claims in their home country. Consumers are not required to sort of travel overseas in order to bring a claim. And if it's a business-to-business contract, then it's up to you. You can choose. Okay. Obviously, the bigger the entity is that you're contracting with, the more likely they'd be pushing for English law. So, for example, if you were selling into John Lewis, they're very unlikely to agree to a contract being governed by Irish law. So that's a factor as well about the bargaining position of the parties. Okay, next slide, please. So our next sales method to contrast with direct sales is using an agent. So an agent can be an incredibly valuable tool. They're somebody who understands the local market and has great connections there. And their job is to introduce you to customers, create sales leads for you, but they might also help to do some of the negotiation of the sales process and the contract. So the key thing to be aware of with agents is that you don't have you have a contract directly with the agent, so that's the first contract you have, but you also have a contract directly with the customer. So the agent is not a party to the contract with the customer. So think about it like when you buy a house, you have an estate agent. They help the seller of the house go and find people who want to come and view it and might be interested in buying it. They help negotiate the price, they help negotiate the completion process, but they don't own the property that is being sold to you. You are buying the property directly from the seller of the house. The agent is just a broker, they're an intermediary. They are helping to grease the wheels of the process. So you need a contract with the agent that sets out the basis on which you appoint them to act on your behalf, the basis on which they're entitled to represent you and earn commission. And we'll talk about that on the next slide. But you also need that direct sales contract with your overseas customer. So all the stuff we talked about on the previous slide in terms of that international sales contract is equally applicable to agency. You need that. It's just that you also need an agency agreement. Okay. So what's good about using an agent? Well, the great thing is that you get to tap into their local knowledge, their local relationships. They can shortcut some of that process for you, and that can cut the sort of marketing efforts that you would otherwise need to undertake. It also means that you can retain control on the price that you sell the goods or your services or your software to the overseas customer. You are the party to that contract with that overseas customer, so you set the price, you set the terms of that contract. The agent might be authorized to help negotiate some of that, but it's all under your control. So the challenges of using an agent are you lose a bit of your margin because you pay a commission to the agent in exchange for their efforts. And also they are entitled to some legal protection, which I'll talk about in a bit more detail. But a lot of people say, well, if an agent is going to build up great sales in a market for me that I wouldn't otherwise be able to access, then giving them a slice of my profit is a small price to pay for getting those additional sales. Okay, so we've talked about the fact that we need two contracts, we need the agency agreement, and we need the international sales terms. Okay, let's have a look at the next slide then. So what are we going to put in our agency agreement? A very important term is to determine the basis upon which the agent is appointed. What is their status? Now, you can appoint an agent on an exclusive basis. That means you are not allowed to appoint any other agents in the market, and neither are you allowed to enter into direct sales in that market. Everything has to be funneled through that agent. And if you don't put the sales through the agent and you do sell either yourself or via other agents, then your exclusive agent would be entitled to commission on those additional sales. So basically, if you grant exclusivity to your agent, they have got your market locked up for however long they're appointed for. Okay. So what can be better from your perspective as a supplier is to go for a sole appointment. That means you can't appoint any other agents, but you can sell yourself. Okay. And then the third option is you appoint them on a non-exclusive basis. That means the agent is allowed to sell in that territory, you are allowed to sell in the territory, and you are permitted to appoint additional agents. Now, obviously, that gives you the greatest flexibility in terms of maximizing your routes into that market. And it also means that if your agent isn't doing very well, you don't necessarily have to sack them. You could try to drum up the sales yourself or appoint a second agent in that market. So non-exclusive gives you the most flexibility. Next, we want to specify what our territory is. Let's assume in this case it's the whole of the UK. But we will want to think about whether there are any customers you want to take out of that pot to carve out. So it might be that you already have relationships with some customers that you have put the hard work into building and you don't want to pay the agent commission on those sales. In that case, we say these are reserved customers. You don't get access to those. No commission is payable on sales to those customers. Commission next. So how much are you going to pay them? So you need to think about whether you pay them commission on all sales into the market or whether it's only sales that have been exclusively procured by their efforts. Okay, so if somebody contacts you separately by email without having had any contact with your agent, does the agent still get their commission or not? And then we also need to think about what happens after termination. If there's any sales that the agent has helped secure but weren't completed during the term of their agency, do they get commission on those post-termination sales or not? Then authority. There are two different ways you can appoint agents. You can either appoint a marketing agent. That means they're entitled to go out and promote your business, but they can't enter into contracts on your behalf. Or a sales agent. A sales agent is granted much greater authority. They can enter into contracts on your behalf. Most people prefer marketing agents because they want to keep control. And then just like with our international sales contract, we need to know what the governing law of our agency agreement is and which courts are going to sort out any disputes for us. Okay, next slide, please. A very important thing to be aware of when you're appointing agents is that in a lot of countries, they are entitled to legislative protection. In the UK, that's called Commercial Agents Regulations. And this is EU-wide legislation. So even though the UK has left, we have still kept this legislation. So it applies in the UK and it applies to sales anywhere else in the EU. There's slight variations in what that legislation says in each country, but the principles are largely consistent. And even outside of the EU, you might find that countries have local laws which protect agents. So you always need to take local law advice when you're stepping into a new territory. So in summary, this local law, this protection for agents says that there will be a minimum notice period, and that normally depends on how long the agent has been appointed. There are default duties. So for example, the agent and the principal owe each other duties of good faith. And the really important one that grabs most people's attention is that the agent will be entitled to a compensation payment on termination of the relationship. And that applies in most circumstances. So it's really important that if you are appointing an agent, then one, take local law advice so you understand what the impact of that legislation is. And two, get your contract properly drafted so that it is compliant with the local law, and also so that there are a few tips and tricks we can put in there to help minimize your liability on termination. You can't contract out of the commercial agents regulations, and any attempts to do that would be void. But there are ways that we can make sure that the contract is as robust as possible to minimize that protection at the end of the relationship. Okay, next slide, please. So we're moving on to distribution as our next sales channel. So if you look at the diagram there of the contracts in the middle, you can see that it's different to agency because you have one contract between you and the distributor, and then the distributor has a contract between itself and the end customer. So you are not a party to the contract with the end customer, and that's a really important difference. So what do we say in our distribution contracts? This is giving them a lot of control over how they represent you in the market and your products. And so we want to put quite a lot of controls on that. Now, there's a limit to what we can do. You aren't allowed to dictate the end price that they charge to customers. That's called retail price maintenance, and that is illegal under competition law. You can impose some controls on what that pricing is, but if you're going to do that, you need to take legal advice because you need to be very careful not to breach competition law. So what are the benefits of using a distributor? Well, the great thing is that once you have made your sale to the distributor, you're done. They have purchased your goods, they take title in your goods, and you bank the money. So that's brilliant. You don't have to worry about whether they then sell those goods onto your overseas customer. That's not really your problem. They have taken the risk at that point. So you're selling to them and then they resell to local customers. So we've talked about the challenge of pricing. Also, you have less control generally in the market. But if you do want to maintain really good control over your brand in the end market, then you need to use your distribution agreement to do that. So, you might set marketing guidelines. You might have a very long distribution contract which says exactly what they can and can't do, which obliges them to enter certain marketing commitments, etc. So you can impose controls on your distributor, but if you want to do that, you're going to have to use your contract and get it really well drafted. We talked with the agent about the fact that they're entitled to legal protection in virtually all circumstances. Now, in the UK, there is no statutory protection for distributors, so the same rules do not apply for distributors. So that's a really big advantage of using distributors versus agents, and a factor to take into account. Because otherwise, you're going to have that termination payment to your agent in most circumstances. With distributors, you don't have to worry about that. In some other countries within the EU and further afield, there are rules that protect distributors in the same way as protect agents. So if you are contracting, if you're looking at markets beyond the UK, then you need to think about that. But in the UK, you don't need to worry about that local law protection for distributors. Okay, so what contracts do we need? We need one contract between you and your distributor, and that will be a distribution agreement, and that will incorporate your international terms of sale, because we need all of that same stuff in terms of the sale to the distributor as you needed in your sale directly to the end customer. We need to control the warranties, limit your liability, deal with delivery terms, etc. So you have the distribution agreement, which wraps in the terms on which you appoint your distributor, what they have to do, etc. But then we also have the international terms of sale included as part of that contract. And then they enter into the contract with the overseas customer. Okay, and you're not a party to that. Okay, next slide. So key terms in distribution agreements, you can see that there's a lot of similarity with agents. Again, we need to know whether we're appointing them on an exclusive, a sole, or a non-exclusive basis, and that's exactly the same as agency. If you appoint a distributor on an exclusive basis, you cannot sell yourself into the territory. If you appoint them on a sole basis, then they are your only distributor, but you can sell yourself as well. If they're non-exclusive, then you can sell via that distributor, you can sell yourself, and you can appoint other distributors and also agents as well. So a lot of distributors by default ask for exclusivity, and they ask for a long term. And that really puts you in a very vulnerable position, because if the distributor doesn't perform well, then you are locked out of that market for the duration of that term, unless you can prove that they have performed so badly that you're entitled to terminate. Okay, so be really watchful of that, and we'll talk about that a bit more on the next slide. Territory, again, just like with our agency agreement, we need to fix the geographic scope and think about whether there are any reserved customers we want to carve out of the arrangement. Key rights and obligations. This section is really important because we want to say to our distributor, if you are earning the right to represent us in the market, then we need some commitments from you. So minimum purchase obligations are absolutely critical. I would say you always want to set the minimum benchmark you're expecting in terms of how much they're going to buy from you. And that's even more important if you're appointing them on an exclusive basis. And then essentially you're granting a distributor a trademark license. You're granting them a right to use your branding in the local market. So we need some controls over that to make sure that they are protecting that brand for you. They are a custodian of that brand. And then termination rights are absolutely fundamental, particularly if you're operating on an exclusive or sole basis. You need to be able to say at what point the distributor has not done a good enough job for you so that you can get rid of them and either sell yourself or appoint a new distributor. And sometimes it's about bad performance on the part of the distributor, and sometimes it's about the fact that you just have a change of strategy. You decide you don't want to go through a distributor anymore. You have built up your presence in the market enough that you want to sell direct. Terms of sale we've talked about, so it's all the stuff we had in our international terms of sale. And then again, critical to determine which law applies to the contract and who is going to resolve any disputes. Okay. One thing I would say is that most clients come to me when they have a distribution agreement that they want to get out of. So their distributor isn't performing well enough, and they say, how can I exit this contract? How can I sack my distributor without them suing me? And often their contract just isn't good enough for them to be able to do that. So sadly, people approach me a lot more when they're in disputes with their distributors than when they do at the start of the process, when we could have drafted a really good distribution agreement that would have given them the protection that they needed to exit without liability. So that's something to think about. Okay, let's have a look at the next slide then. So common pitfalls in distribution agreements. Local law compliance, as I said, that's more one for outside of the UK. The UK does not have any legislation that protects distributors in the same way as agents. But you do need to think about things like competition law and anti-bribery particularly. So the Bribery Act 2010 is the UK's bribery legislation, and it says you will be responsible for any bribery acts committed by associated persons. And associated persons covers agents, distributors, anybody who provides a service for you or does something to help your business. So you really need good anti-bribery and corruption provisions in your agency and distribution agreements to say, you must not bribe anybody. And if you do, I can terminate this contract immediately, because you have vicarious liability for those agents and distributors. And what that means is that if they breach the Bribery Act when they are acting on your behalf as your agent or distributor, then you are liable for that breach. There is a defence. If you can show that you've taken reasonable steps to provide bribery, then that is your get out of jail card. So that's why we really need to make sure that your contract has got good anti-bribery and corruption provisions in as part of those steps that you've taken to prevent bribery. Okay. Another big pitfall is that people fail to think about the bigger picture. So they think, right, I'll appoint one distributor in the UK, I'll give them exclusivity, but actually they've asked if they can have this exclusivity for the whole of Europe. So yeah, sure, why don't I do that? And then they think, you know, they kind of are caught in knots then, because actually the distributor only really has good connections in the UK. They don't really have good sales channels in those other countries, but you've granted them exclusivity and then you're a bit stuck. So try to think ahead of time about who you're going to appoint where, give people the smallest possible markets you can, and then let them earn additional markets over time if they can prove to you they can make a go of it. And avoid exclusivity if you can, just to give you as much freedom as possible. We've talked about that inability to terminate poor performance. So absolutely crucial to use minimum performance obligations, because that gives an objective benchmark. You can prove whether the distributor is hitting those or not. And then you can say, if you don't hit those, I will have the right to terminate or downgrade your exclusivity. Okay. All right, next slide. Influencers. So influencers are not actually a route to market in terms of a sales channel, because the influencer will not normally help actually get involved in the sale. What they do is they are a marketing method, basically. But you still need a contract with them, because you need to, they're representing your brand. You need to have some controls over that. So particularly if you're selling consumer goods, then influencers are a great way to increase your profile in new markets. You know, social media is king for consumer goods in particular. So if you're going to collaborate with an influencer, you need to think about a couple of things. One is research their background, make sure there's no skeletons in their closet, make sure that they align with their brand values, make sure that the other stuff they're promoting is consistent with the message you want to give about your goods and services. Next, you need to think about legal obligations. So for example, if they're promoting your products or services on a paid for basis, then in the example in the UK, then they need to use #ads to make it clear that they're being paid for those promotions. You probably want editorial control over their content. So, you know, do you want the right to check that the statements that they're putting out there are true and that they align with your brand values? You also want to be clear who owns any IP in respect of the products. You want to know how long you appoint the influencer for and when you can terminate the relationship. And a really important thing is to have a non-embarrassment clause. So if they do anything that causes you embarrassment, or something comes out of the woodwork about their past behavior that makes you think, yikes, I do not want to be associated with that person anymore, you just need a really broad right to cut and run, to terminate the contract with them. So that's influencers, and I've got some articles that I've written about key pitfalls in distribution agreements, and also what to put in social media influencer agreements. So I think we're going to be able to circulate those to everybody after the call, and that can give you a bit more detail on influencers. Okay, next slide, please. So the last section of our presentation is about customs and logistics. How do you actually get your goods overseas? So one thing to be aware of is if you are transporting goods on a domestic basis, you might not be aware that there are some international logistics conventions that apply to international shipping. And what they do is they set a very low liability limit for the haulier. And so you might engage a freight forwarder and you look at their terms and they say, we will only be liable for 2 special drawing rights per kilogram if we lose or damage your stock. And you think, well, that's crazy. Like, obviously my stock is worth a lot more than, should explain that special drawing rights are a kind of international equivalent of currency, and one special drawing right is equivalent to about £1 at the moment. So basically, they're limiting their liability to £2 per kilogram. And you think that no way compensates my loss. But that is a product of these international logistics conventions that apply on a mandatory basis to international shipments where the sending country or the receiving country are parties to these conventions. And so what you need to do is you really need your own goods in transit insurance, because that's the sort of usual solution. You get a little bit of liability protection from the haulier, and then you top it up with your own goods in transit insurance. Okay. Customs rules are the other sort of big shock to the system when you're moving from domestic trade to international trade. And so you would normally appoint a freight forwarder or a customs agent to help you out with that stuff. And then finally, you need to use Incoterms in your sales contracts for goods to determine what your responsibility is for shipment to your end customer. So let's have a look at the next slide, and that will give us a bit more detail on this. So Incoterms are basically a contracting shortcut that we use when we're trading internationally. There are a set of international rules, and there's different flavors. And so you can choose, for example, Ex Works, which is the lowest level of obligation on you as a seller. That means all you have to do is make the goods available for collection in your home country at your premises by the buyer. And they're then responsible for the costs of collecting those goods and shipping them into the UK and doing everything in between. So clearing the goods for export from Ireland, clearing them for import into the UK, ensuring the goods through all of that transit process. So Ex Works is the lowest level of obligation. At the furthest end of the spectrum, at the opposite end, we have delivery duty paid. That means you are responsible for shipping the goods all the way to the end destination that the customer specifies. You have to clear them for export, clear them for import, insure them for the full duration, and pay for all of that. Make sure everything works along the way. Sorry, I'm just going to sneeze. And then all of the others kind of do something in between. So they set different levels of obligation. So if you have never heard of the Incoterms, worth doing a little bit of research on those, because they're very important when you're contracting internationally. Okay, next slide. So key tips from this presentation. First of all, understand what the best route for market is for you. Is it agents, distributors, direct sales? Then think several steps ahead. Don't just think about your first appointment of an agent or distributor and grant them the earth. Think about your overall strategy and make sure you aren't too generous with your first appointment. And nobody gets this stuff right straight away. Everybody learns from you working with agents and distributors, usually by mistake. And so, just expect to continually improve as you grow your overseas markets. What shouldn't you do? Don't rely on verbal agreements. Contracts are absolutely essential. Don't assume all local laws are the same. You need to take local law advice. And don't go it alone. There's loads of people that can help you, whether it's Enterprise Ireland or lawyers or local support in the market. Lots of people that will help you avoid pitfalls. Okay, that's me.
That's brilliant. Thank you, Lucy. Some wonderful insights there on the different types of sales channels and some of the nuances between each type. So yeah, really interesting presentation there, and hopefully something that everyone can take away today. So there's one question in the chat, Lucy. I wonder whether you might be able to answer that just via by typing. Just keen to get our client panel
sure,
in,
will do.
so that we can hear some of the principles that you've discussed sort of play out in real business scenarios. So if I can invite Jen Ronan from Tynes, Siobhan Kehoe from Rathbornes 1488, and Daniel Izquierdo from Micron Agritech onto the screen. Excellent stuff. Brilliant. So I think if we start with a very brief introduction from each of you. So Jen, I wonder whether you can give a very brief overview of yourself, what you're responsible for in your company. That'd be great, please.
Yeah, absolutely. Can you hear me?
Yep.
Brilliant stuff. Lovely to meet everybody who's on the call. I'm Jen Ronan. I head up partner strategy and programs at Tynes. Tynes is an Irish founded technology company. We describe ourselves as an intelligent workflow platform. We essentially free up organizations of all different shapes and sizes to remove some of the repetitive tasks that drain their teams day in, day out. And we help them bring their tools together in smarter and more effective ways. We are co-located here in Dublin and also in Boston. But we kind of operate on a global basis. We have customers, here in Europe, in the US, LATAM, and in APAC as well. And yeah, really excited to be here. Thank you for having me, Richard.
Brilliant. Thank you, Jen. Siobhan, if I can pass over to you for a quick intro.
Sure. I'm Siobhan from Rathbornes Candles, 1488. So we're the world's oldest candle makers and Ireland's oldest company. We still make all our products in Dublin today. And we export to the US, UK, Canada, Japan, South Korea, Middle East. And yeah, all luxury home fragrance products.
Wonderful. Thank you, Siobhan. And Daniel, last but not least, a quick intro.
Yeah, hi everyone. I'm Daniel. I'm CEO at Micron Agritech, and essentially what we do is we allow veterinarians around the world to test animals for parasites using their mobile phones, and they get results in minutes through an AI model, so they can make a treatment decision based on the result instead of doing what they do at the moment, which is just give a blanket dose of medication on a regular basis. So we help them be more selective with their treatment and keep animals healthier in a more sustainable way.
Super. Thank you, Daniel. That's great. Thanks, everyone. So, I mean, maybe sticking with you, actually, Daniel, when you first entered the UK market, what was the sort of biggest challenge that Micron Agritech came over when selecting the right type of sales channel for your business?
Yeah. So I suppose maybe firstly, the interesting thing about Micron is that we're a goods and services business. So we do software and hardware. So we do have a physical component. So we needed fulfillment, distribution, sales, and everything that comes with then the aftercare. So we did work quite hard to find the right distributor. In our industry, the channels tend to be quite conservative, Richard. Distribution tends to happen through the pharmaceutical companies, so the sellers of our medication. And it's like old school medical sales almost, door to door, trying to meet the vet and sell them the product. And so at the beginning, we decided that we'd go with that approach, given that it's the approach that works. But I will say that we quickly learned that with a technology as novel as ours, it was important to come up with a more novel approach. And I will say that since then, we have set up direct distribution in the UK market.
Yeah, fantastic. And is that something that you kind of changed or pivoted as you went along? Did you learn sort of things from your first distribution agreement to maybe your second one that you kind of took learnings into each one?
Yeah, absolutely. I'd say we did learn a lot, and we have distribution agreements still in place. They tend to be exclusive for other regions. But what we've definitely learned, at least in our space, is that we need to be quite selective about the products that our distributors are also distributing, because one of the things we're trying to do is reduce the amount of medication that's given to the animals. So there's obviously a bit of a conflict of interest if the distributor sells that medicine as well. So that's one thing. And then secondly, in terms of the contract, I mean, going back to the presentation that's just gone there, making sure that there's good targets, good reasons to be able to make it co-exclusive or terminate the agreement. Also, the reporting clauses, I think, are really important. So what are the requirements for the distributor? What do they have to report? Maybe you don't want to just get a report on the sales, but you also want to get reports on the sales activity. Clauses on how much marketing work they should do. All of that stuff is important, and it's things that we've learned, I think, from our early distribution agreements, and we've implemented into the more recent ones. Yeah,
that's brilliant. Thank you, Daniel. Jen, maybe if I can bring you in here. Perhaps you can give a bit of an overview as to, I guess, the types of sales channels for Tynes, and I think from our conversation previously, I understand that kind of partnerships are your preferred route, and kind of why that is, and what the reason is for Tynes for doing it that way.
Yeah, absolutely. So we kind of describe ourselves as customer centric. We'll generally try and meet our customers where they are in terms of how they would like to purchase our software. However, we do know that we get massive additional scale and impact by collaborating with different third parties in different geographies in order to maximize kind of our reach. We know that if we can do that, we essentially are able to tap into a whole ecosystem of advocates and evangelists who are able to go out and tell our story on our behalf. That we generally categorize those types of partners into two buckets. There are the kind of what we describe as the reseller type partners, which Lucy referenced in her presentation earlier. These are the types of trusted advisors that our customers go to every single day in order to inform the software purchasing decisions that they make. And we work with them. We have reseller agreements in place with them that cover the terms of those relationships. We work on a non-exclusive basis across the board just by nature of the type of business that we're in. And then we also have what we call technology partnerships, which are much more kind of symbiotic relationships, whereby we work with other software companies that look just like ourselves, where we know our products work really well together. And again, we know that, if we can position our two solutions in a way that makes sense for our shared prospective customers and our shared customers, it actually helps to create more impact and value for those customers when they purchase our softwares together. So they're the two types of ways that we consider when we're looking to expand in markets like the UK.
Yeah, no, that's brilliant. On those technology partnerships, Jen, are there kind of things that are key? Like, I can imagine IP, that kind of thing probably comes into it quite heavily for those sorts of agreements, would it?
Yeah, exactly. So we have technology, what we call tech alliance partnerships agreements in place for all of those. And while it's kind of a less commercial type of a relationship than a reseller agreement, it is important to have infrastructure in place that defines our ways of working together. So yeah, it's things like IP, indemnity, like how we want to show up when we co-market and we co-sell together, etc. So, to ensure that kind of nobody is left with any surprises as the relationship progresses and as our way of working, as two kind of like equal constituents in that relationship goes forward. Yeah,
brilliant. No, that's great. Thank you. And Siobhan, maybe jumping over to you and the world of retail. I know you've got experiences, going through distributors or going directly to retailers. What do you sort of see the pros and cons when it comes to kind of each approach that you adopt?
I guess in terms of distributors, you really do lose control, as Lucy said, and then you're also sharing the margin. For retail, you really need to be on the ground no matter what route you go with, because they are selling to stores. That is your window to the world, really. So you need to make sure they're looking after your product, that you have people checking, going in store, making sure that they each, whether it's direct, your actual store that they're looking after it, or your distributor. The being direct, of course, you have control over promotions. You can really check and make sure, as a luxury brand, we want to ensure as far as we can, while taking care of the anti-competition law, that there isn't a lot of promotions happening which can ultimately damage the brand. And then I guess in terms of distributors, if you don't have a warehouse in the UK, it's a nightmare right now. So they can handle that part for you in terms of logistics and getting your stock over there, which is a really big thing right now. What else? Let me see. Margin control. Yeah, big, but I would say merchandising. Make sure that also you've really researched your distributor well, that it is the best one for you and that's going to actually look after your product.
Yeah, absolutely. And I know Lucy mentioned in her sort of presentations a little bit around the kind of marketing packages that you might have to have in place with retailers. And I know, Siobhan, you said they were kind of commonplace now in more and more agreements that you're coming across. I mean, how do you manage them? What do you have any kind of tips on kind of how you go about navigating those sorts of packages within agreements?
Yeah, so it's becoming more and more difficult with department stores wanting and requesting more in terms of this, in terms of them asking you to subsidize their marketing budget, really, and they'll give you X, Y, and Z as a result. So they'll put you up their page on their website, they might put you in a banner, they might put you in their email marketing, for example, or promise you a particular position in store. So again, you really need to be on the ground. You need to send somebody in, and if you've agreed to these things, you need to check up and make sure they're actually doing it, and that it is the best course of action for you. So the reason for doing this is to raise your brand awareness, and hopefully then you'll sell much more direct on your own website, and also within the store, and strengthening the relationship there. For me, I would say that there's no point in selling a product onto direct to any store really and expecting it to sell, or just be happy, oh great, we got a sale. You do need to support them. So whether it is supporting them in terms of that investment in terms of marketing, or your own marketing, whether you need to be investing in the region, whether it is with influencers, whether it is on your own social channels or your own email. But don't just send product in and go, yay, we've sold into this new store and it's going to be great. You need to be checking on it. You need to do your own marketing to support them, and support them in any way you can, in terms of, even if it's gift with purchases as well on launch, or sending to their influencers and people they already have partnerships with, to really drive sales. But as I say, yeah, they're looking for more and more, so you need to weigh it up and then check that they actually do it, if it is something you've agreed to sign up to.
Yeah, absolutely. No, that's really valuable, Siobhan. And I think, Daniel, you kind of touched upon it in your answer earlier as well, in terms of actually like managing those relationships with distributors. And it's not just a case of, once you've got that agreement in place, being able to step back and let things happen. You've got to really kind of set those metrics, set those targets. Maybe you can go into a bit more detail on that, Daniel, in terms of how you go about managing it and what's worked well for you in the past.
Yeah, look, I think the ongoing relationship is really critical, because as you can imagine, these distributors have hundreds of other products that they're handling. Yet the product that you're distributing is the most important thing to you as a company. So the ongoing relationship is critical. What we've done in the past is we sort of stage it out, but particularly at the start of the relationship, we're meeting with the senior teams very regularly, every couple of weeks. As time goes on, that gets reduced to once a month and then to quarterly. But that making sure that the momentum is there and ongoing work is being done, we're both tracking the same metrics and staying on top of the progress that's being made. The other thing that's worked really well for us is having sort of a key person, let's say, internally, that is responsible for our product, sort of champion for our product. And we're mostly in communication with this person. I mean, in some cases, we're in contact with this person over email or over phone regularly throughout the week. But there's one person internally in the distributor that is the champion for our product, and so is sort of living and pushing it on a daily basis within the organization so that it doesn't get lost amongst the hundreds of other products. So I'd say that's what we've done, and it's really, really key, to make sure that we're still at the top of the list as time goes on.
That's great. Really good tips there, Daniel. Thank you. And Jen, maybe you can talk a little bit more on the software side in terms of the ways that you go about incentivizing, the resellers that you work with. How do Tynes manage that?
Yeah, great question. So generally kind of across the board, we offer them a discount on our software licensing fees, which means they can then go and sell it on to the customers at a price that they determine. Similar to what Lucy said earlier on in the conversation, if in a world where they own the end contract with the customer, it's really important that we don't do any sort of price fixing or price setting, etc. So that's generally how it works. So those discounts range depending on what we describe as the tier of the partner. We assign tiers to partners based on the level of engagement we see with those partners. So those partners that are more lent in, that are doing more business with us, that have expertise that's quantified by certifications in our product, get higher discounts, and those discounts can be right up to 30%. But partners that are a little bit earlier in the journey with us get access to lower discounts as well. So basically what we're trying to do at any given moment is reward those partners that we're doing the most with, that we're seeing the most impact from, and that ultimately are translating that impact over to our customers as well, because they know our product inside out. The other aspect of this as well is, those resellers oftentimes have consultancy arms where they're going and offering like post-sale services to customers to again help them get more value out of their software purchases. They're helping them combine with other pieces of software that they may have in their tech stack, or else just helping them to solve kind of some of the business challenges they have with that software. And so again, that's something that we help empower our partners to do as well.
Yeah, brilliant. No, that's great. Thank you, Jen. Just quickly check the chat. I see that we're coming up almost to time. So there's, I think there's another one possibly in there for you, Lucy. Just a continuation of the last question. But perhaps for all the panelists, Siobhan, maybe I can come to you first. If you had to give kind of one key piece of advice to companies entering the UK market around sort of sales channels, what would you pick out there?
I would say know your market, really research it yourself. Don't just rely on distributors maybe and what they say, and really research your distributor well to see what other brands they're working with. See, are they going to report well? Are they going to represent your brand well? And stay on top of them, and make sure your marketing mix is good too. Make sure that your assortment mix, so your product, see what is its USP for that particular market. It may be one thing in Ireland and something a little different in other markets, looking at that cultural difference so that you're showing and sharing your point of view with them, and make sure that the distributors really knows exactly what that is too, so they can represent your brand the best they can.
Yeah, brilliant. Daniel, perhaps onto you, a kind of final top tip.
Yeah, I'd say not too dissimilar, but definitely be very careful and diligent about selecting the distributor, but then be ready to move really quickly after in terms of your pivoting and adjusting your strategy. I'd say that's really the key.
Brilliant. And Jen, perhaps just a final thought from you.
Yeah, I would say like listen to your prospective customers as well, like on the software side of things. Hear from them who their trusted advisors are. About who potentially the most impactful partners that you can select in a given market might be.
Brilliant. That's great. Thanks, Jen. So I see we're up to an hour now. So I think we'll probably leave it there. But just want to say a big thank you to, I guess, everybody on the screen here, the speakers today. Really, really valuable insights shared, and really grateful for the time that you've given up today. And of course, everybody that's dialed in as well. In terms of just a couple of supports that will be available sort of after today's session. So you'll receive a copy of the recording and the slides following today. Lucy also mentioned a couple of articles that she's written, which contain some further information on some of the key topics presented, so we can share those around as well. In terms of, I guess, any Enterprise Ireland clients, if you've got any kind of additional support requirements, then please reach out to your client advisor as the first port of call. For non-Enterprise Ireland clients, so Leos, for example, please reach out to your existing contact points, and for any non-agency clients, feel free to get in touch with the National Enterprise Hub, who should be able to provide you with a bit of an overview over the different kind of supports that might be available to you and your business. But I think that probably rounds us up for today's session. So thanks again, everybody, for your participation, and hope you enjoy the rest of your day. Thank you. Bye-bye.
Thanks, Richard.